Good morning, everyone. It's my pleasure to welcome you to the first plenary session of the 6th IJJO conference, Justice for Children in the framework of the Convention of the Rights of the Child anniversary, challenges and progresses for the next 25 years. Many thanks to the previous speakers. Thanks to Mr. Malus, Mrs. Velkova, and Mr. Dr. Legas for their rewarding addresses. I think that they have provided us for the perfect policy framework for this conference to begin. I think that it was particularly interesting some of the issues that were raised during this first session, such as how a public policy on juvenile justice can be effective and evidence-based policy making, and also the call on action that was done by the chair of the IJJO to professionals and policymakers for the operational implementation of the Convention of the Rights of the Child. In fact, experts and professionals working in the protection of girls and boys involved in the cycles of conflict, crime, and violence, we don't have the right to complain. Since the adoption of the United Nations Convention of the Rights of the Child, there have been many European, regional, national, and United Nations instruments that has been adopted in our field in the last 2 decades. However, the desired effect hasn't been achieved. What are the reasons? Because of this lack of consistency between the policy and the practice, between the theory and the reality. This session aims to analyze the milestones and the progresses that have been achieved until now, but also all the challenges that still remain to be tackled, mainly in issues related to access to justice, crime prevention, and criminal policies. To address all these issues, we have 3 highly qualified specialists on this session. Let me introduce you Mr. Philippe Cori. He is director of the UNICEF offices in Brussels for UNICEF. We also have with us Alexandra Mathijs, policy officer on justice for children of the UNODC office in Vienna. And additionally, I would like to thank Mathijs Euwema for his role as rapporteur of this first session. Let's start with Mr. Cori. Mr. Cori is director of the European Union office at UNICEF in Brussels for the last 6 years, since 2008. He is graduate in international trade in France. He went to study history of art, education, and evaluation at postgraduate level before obtaining a PhD in World Heritage, Branding and Development from the University of Silpakorn in Bangkok, Thailand. Since then, he has gone on to have numerous highly qualified posts at UNICEF, but also at the United Nations systems, which include being a senior advisor on global partnerships and development branding for the Middle East before becoming the director of the office in Brussels. Mr. Cori will address issues related to access to justice, and he will point out the role of the Brussels office concerning the partnership with the EU institutions. Mr. Cori, floor is yours. Thank you.
Merci. Je vais parler en français.
Thank you. I will be speaking in French and later in English. Thank you for your invitation. I am not an expert. You are the experts in the room. I am simply a children's rights activist. I've worked for 20 years at UNICEF. And although not officially called this way, I have lobbied for the rights of the child, internally and externally. Internally because UNICEF was worried that if this were to be politicized, we would not have access to children in these countries. It was a legitimate question. Externally because the world is very diverse, and not everybody wanted a convention on the rights of the child. Everybody had an excuse, and this was our real challenge. And I'd like to share some of the great achievements that this convention has had 2 weeks after the 25th anniversary of what I consider a very important convention. The first challenge we had was to have an argument as to why have a specific convention of specific rights for children, why this was necessary. We had a school of thought that said, we have got all of the conventions in the world already to defend human beings. Why do you need another useless piece of bureaucratic paper focusing on children? Well, 25 years later, we can say that the situation has really changed for children. And this convention on the rights of children, rights specifically tailored for children, recognized the vulnerability of children. And the fact that they had specific rights that had to be upheld, to which we had to adapt and which we had to defend. Infant mortality is already a result we've seen. This is the most ratified text in the history of the world. We only have 3 countries that have not yet ratified it. One is the United States of America, Somalia also, but as we know, the government doesn't. Well, we know that the Parliament is debating it and will be ratifying it later this year. But since they've been having an internal war for many years, they haven't been able to. And Ms. Mogherini last week in Parliament explored the ratification of by the European Union. The EU has ratified the Convention on Disabled People, and perhaps it would be time to also ratify this Convention on the Rights of the Child and perhaps create a European Convention on the rights of children.
Mortality rates of children have really declined sharply over the last 25 years. Undeniable. The Convention was certainly a strong framework for that. We have more, millions of children, around 90% in many of the countries, having now access to education. It was not the case 25 years ago. You have children now having access to health sectors. In terms, just taking, immunization. The coverage against measles and polio we are very close to eradicate polio. Really affecting children, crippling children for their life. So a lot has been done in that sense. Access to clean water. I could go on, and you have all the MDGs that we are now talking a lot within the post-2015 agenda, which have moved forward a lot, having, a rights-based approach to children, and at the same time having the world engage legally in the process of sustainable development. At the end, it's about sustainable development. Having a committee on the rights of the child, having to monitor every 5 years what every country having ratified this convention had actually done for children in terms of their access to health systems, education, and so on. So truly a success story in that sense. But now a lot, is still to be done. We have mentioned, we have millions, we have, for instance, 70 million girls from 9 to 14 every year suffering in their flesh physical violence. 1 out of 3 children, adolescents, teenagers are bullied. You have 180 million of children in this world still engaged in harmful practices of child labor. And I could go on and on and on. Again, the disparities, this world, our world is exploding because of the disparities, the growing disparities. We have, on one hand, for instance, to give you, in terms of legal, the fact that you are recognized as a person with a name. You can exercise your right. The richest children, 80% of them are registered at birth. The poorest, not even half. So you know what it means for the other half, being trafficked, not being protected, not having any access whatsoever in any system of social protection system, health, education, and so on. So this is where we need strong laws, we need strong system. And what we learned from it was good to recognize these rights. But now we are in the phase where we have to continue to realize them. and for every child, everywhere, and particularly the most disadvantaged in this terrible world in terms of equality. It's a shame for all of us. So the focus on the most underprivileged is extremely important. The issue of equity is essential to justice as well. And this is where I'm coming. We have to use, this, we have to first recognize that we have to adapt the system, the justice system, to children. We have a specific convention. We need a specific adjusted justice for children. I mean, a lot of progress has been done in many instances, but not everywhere. I mean, I know with the EU we work a lot, and I must say that the colleagues from the DG Justice and especially the Child Rights Unit, they have to be commended for the work we have been doing in some instances, and the civil society is certainly even more engaged there. I mean, for instance, we had in the CECIS region, to take just a neighborhood place, in 11 countries, we did together a study on the impact of the justice system on children, to monitor, particularly in terms of the deprivation of their liberty. What we could say, I mean, it was about 2006, 2012 in terms of the window we had studies. What we can say is that there is far more traction, and we had a meeting with ministers of justice, and thank you, Madam Minister, to have opened this meeting, engaging more and more, and we have seen this in the CECIS region. They came here, they recognize failures, the way is not to blame without any construction behind, but it's also the way to share practices, to engage, push politically, and the civil society is extremely important, the European Parliament as well there. So you have, in some countries, even 80% decrease in terms of the number of children in jail or being deprived of their liberty. So it's moving. So this is where we have to capitalize. We have to push. Now we can document that it is moving in the right direction, but not everywhere, obviously. So we have to continue there. So first, recognize specific rights and realize these rights for all, everywhere, and especially the most disadvantaged. It is truly now, even the long-term plan of UNICEF, 2014-2017. I mean, UNICEF probably did not yet realize that, what it means to realize the rights of every child everywhere, and especially the most disadvantaged. But it's a big change. And this is where justice systems come in. We have to adjust, we have to adapt, so a more child-friendly or child-sensitive justice, not only juvenile justice. You have to go beyond the juvenile justice. It's justice also for children. You have to include them. So there is a change there in terms of the personnel, and the President has mentioned this in the speech, to have prosecutors, to have judges, and to have social workers, more having the same voice, because what we find even in Europe, everybody is working in silos. There is no joint approach around the child-focused approach of those dealing with justice. So this is one important thing. And the way we practice justice for children, it should be far more empowering children to claim their rights. They have rights recognized now since 25 years, and they have to claim their rights. For the moment, the justice is not really seen system as a way to claim your rights to health, your right to education, quality education, your right to protection from abuse, from violence, from exploitation. So there is here, perhaps a challenge for those working actively in the justice world, to make it more meaningful. The Committee on the Rights of the Child, which I referred to, had even made a comment on, to give meaning to these rights, you need to have remedies to redress the violations. So this is where we have here, I would say, a thread for a strategy for the next 25 years. You were asking us, what's next for the 25 years? So this is really making this right more meaningful by having a more committed justice in terms of their personnel, in terms of their practice. It's very often intimidating for a child to go through a judicial system. And it's not empowering. It's very often disempowering. I'm sure you have seen many of these situations. So it's probably not the best way today in many countries to realize their rights. And if you are not lucky to be among the most underprivileged, take children with disability. Take children members of some, minorities. You mentioned, Mr. President, Monsieur Lamos mentioned the Rome community, extremely discriminated. So if you are from these communities, your access to justice will not be rosy. There is a lot to do there. So that's one area. And we should also work together on getting better data, quality data in terms of knowing the situation of children is because very often it's commingled with adults' data, so it's not clear. And evidence-based policy is really where we really make the right decisions for public policies and changes. So collecting data as well. But you have a strong civil society, and many of the representatives of the civil society are here, is extremely important to continue to put pressure to move forward. That's really a network, and I'm sure at the community level, it's really making a big difference. And the other side is also to help children claim their rights. Very often, children are not aware. Les enfants ne sont pas au courant de leurs droits, très souvent.
Very often, children are not aware of their rights, so it's up to us as organizations and justice systems to ensure that children are aware of their rights, so that through the justice system, they're then able to demand that their rights are respected. We haven't yet reached that point. Often, children are involved in a relationship with the parents, with the family, but which is of course important, but something which is an obstacle when there is a conflict in the family, there you do have a dilemma. And often it's the adult justice system, given the maturity of children, doesn't give them real access to justice. So this is the kind of challenge that is facing us all. And I think that civil society, the European institutions, the European Parliament, as you know, adopted a resolution last week on the 25th anniversary, which was deeply committing with regard to children's rights as far as justice is concerned, access to justice. So there are members of Parliament in the room, so I think we ought to congratulate them on taking this adopting this virtually unanimous resolution. Mrs. Mogherini, the European Union has a very important role to play, a third of world trade, which could be used to push forward the agenda of the child, in particular access to justice, in particular in countries where the European Union is engaged in trade, where it has geopolitical interests. And we have to use this strength, this ability to move agendas forward. And very often, and this is my last point, we have to push forward justice, rights to children, children's rights, access to justice for children. And of course, the rule of law, governance.
The agenda the EU is connected with. So that's a human rights agenda. I mean, you have human rights dialogue, you have you have all this dialogue that the EU is orchestrating, using its own outreach. And this is very important that we continue and having Mrs. Mogherini pushing this throughout the external policy and the security policy of the EU. And you can count on us to continue to push on that side, because we think this is the right way to move. And we have had successes over the last 25 years, and we should continue this way to realize these rights and a true access to justice for children. Merci de votre attention.
Thank you so much, Philippe, for this inspiring speech. I think that you did a great global framework, and you also highlight some of the milestones that you have achieved in terms of the EU agenda and how you have been lobbying for the last 6 years in terms of children's rights. Congratulations for all these goals achieved. That's time to give the floor to Alexandra Martins. I'm going to take the advantage of having Alejandra here to thank her personally and institutionally for her commitment on the topic, but also for all her support to the IJJO, and she always has been involved in our activities, but also she has been supporting us in all the activities that we are running in the Asia-Pacific region. And I don't want to lose this opportunity to thank Alexandra Martins for being here today, but also for her personal and professional commitment with our work. Alexandra Martins works as crime prevention officer with the justice section in UNODC headquarters in Vienna. She's focal point at the UNODC on justice for children. She started her career in 1998 as a criminal lawyer in Sao Paulo, Brazil. From 2001 to 2005, she worked as program officer for Save the Children. She's originally from Brazil. Alexandra studied law at the University of São Paulo, and she focused her PhD thesis on juvenile justice, particularly on alternatives to imprisoning to children in conflict with the law. Alexandra will talk about strategies for preventing and responding to violence against children in conflict with the justice system. During her presentation, Alexandra will introduce the new normative instrument, UN model strategies, and practical measures on the elimination of violence against children in the field of crime prevention and criminal justice that has been very recently adopted. Thanks for being here today and for presenting this interesting instrument. It's your floor. Thank you.
Thank you, Christina. Excellencies, distinguished participants, ladies and gentlemen, dear friends. On behalf of UNODC, I would like first of all to thank IJJO for having invited us and for having involved us also in the organization and for being here today participating in this conference, which is of key relevance also for the work of UNODC. So for those who are not familiar with the United Nations Office on Drugs and Crime, we are part of the United Nations Secretariat. We have our headquarters in Vienna. And UNODC is mandated to support member states of the United Nations in preventing crime and violence and in strengthening the capacity of member states to promote effective, fair, and child-friendly juvenile justice systems. The title of my presentation is Preventing and Responding to Violence Against Children in Contact with the Justice System. And I would like to take the opportunity of being here today and being with all of you to briefly introduce you, as Christina mentioned, a new normative instrument. It's a non-legally binding instrument. It's a new set of standards and norms in the field of crime prevention and criminal justice, which is titled United Nations Model Strategies and Practical Measures on the Elimination of Violence Against Children in the Field of Crime Prevention and Criminal Justice. And I start by saying that it's a very long title, very difficult to memorize. This is obviously the result of a very intensive negotiation process by member states. So this is the result, not very welcome by the United Nations, but that was the choice of member states. And I would like to, during my presentation, to focus on three main pillars. The first one, I would like to give an update or to tell you a bit about the history and the process that led to the approval by the international community of this new normative instrument. Then I would talk briefly about what are the objectives and the scope of the instrument. And finally, I will talk a bit about the content, in particular about strategies aimed to prevent and respond to violence against children who are in contact with the justice system or within the juvenile justice system. I think that many of you know that in 2006, the United Nations Study on Violence Against Children acknowledged that violence against children is a widespread phenomenon that affects millions of children all over the world. No country is immune to violence against children. And the study also highlighted the high risk of violence faced by many vulnerable groups of children, including those who are in contact with the justice system, and in particular, those who are deprived of their liberty. So that's why this topic for us has a very strong linkage with children deprived of liberty, and that's why we would like to take this opportunity to stress the importance of preventing and responding to violence against children, especially when they are deprived of their liberty. So as a follow-up to the 2006 United Nations Study on Violence Against Children, in 2012, as a follow-up to the World Report, UNODC, jointly with the Office of the High Commissioner for Human Rights, OHCHR, and the Special Representative of the Secretary General on Violence Against Children, submitted a report to the Human Rights Council, which is one of the policy-making bodies of the UN, outlining what are the risks and contributing factors to violence against children when they are within the juvenile justice system, and what could be, and then we formulated a number of recommendations, what could be done to prevent and to respond effectively to this phenomenon. I'm mentioning the UN study and the joint report that was submitted in 2012 to basically outline that that was an opportunity to create the momentum at international level and to raise the attention of member states of how important is this topic. So I think it's fair also to acknowledge that juvenile justice is a neglected area by the international community and by national governments as well. States, because of financial constraints and other valid reasons, tend to neglect the situation of children who are in the juvenile justice system, the rights of children within the administration of justice, and in particular, the rights of those who are deprived of their liberty. So we tried with the report submitted to the Human Rights Council to create the momentum and to call the attention of the international community to the need to do something in this area. So for those who are not familiar with the development of international legislation, international law is developed by the policy-making bodies of the United Nations, and this is one of the added values of my office of UNODC, because one of the tasks that we have is to support member states in the development of international legislation. So the Beijing rules, the Vienna guidelines, all the international standards and norms in there of juvenile justice, those that will spell out what is already written in the articles, contained in the articles of the Convention on the Rights of the Child. So all those instruments were developed and facilitated by UNODC. So having this normative function, UNODC received a mandate from the General Assembly in 2013 to develop a new set of standards and norms, and specifically on violence against children in the field of crime prevention and criminal justice. So the challenge we had in front of us was to align the decisions of three policy-making bodies of the United Nations. First of all, the Commission on Crime Prevention and Criminal Justice, based in Vienna, dealing with issues of crime prevention and criminal justice. The second policy-making body is the Human Rights Council, and the third one was the General Assembly. So aligning decisions of three policy-making bodies and putting diplomats in three forums together to decide on adopting or developing a new international normative instrument was not an easy task. But that happened, so the instrument was developed in close cooperation with UN entities, and I here would like to thank UNICEF, in particular, who had a key role to play in the advisory group for the development of this new normative instrument, with the Office of the High Commissioner for Human Rights, the SRSG on violence against children, and also in close consultations with NGOs. IJJO was one of the key players. I can mention many of the colleagues that I see in the room from other NGOs, Terre des Hommes, Penal Reform International, Defense for Children International, members of the academia, meaning that was a process that involved a number of stakeholders and that took into account different perspectives and different challenges coming from different parts of the world. So to make a story short, there was the approval of this new international instrument by the General Assembly in September this year, and there will be the final adoption in December. So what we are happy to say is that with the approval by the international community of the model strategies, I will refer to this long title as the Model Strategies on Violence Against Children, it represents certainly a strong commitment of governments to address the problem, and a strong recognition of the problem and the need to provide responses to that. Just to mention that with this, UNODC, and this is why I'm talking a lot about it, has a new mandate which was received from the General Assembly, which is to take measures to disseminate and to promote the implementation of this new normative instrument. We have started developing tools because, of course, it's a 35 pages document. It's not easy to digest. So we have developed tools to explain to policymakers and criminal justice officials what this instrument is about. And we have also developed a checklist for policymakers and for member states to start identifying what are the gaps within their legislation, within policies, and within the operational frameworks, and what needs to be done to start implementing this tool. So, whether you are a judge, a prosecutor, a law enforcement officer, a child protection officer, child protection professional, I just outlined 3 questions that I think that some of us have already asked to yourself at least once. So the questions would be, is the justice system doing everything it can to prevent violence against children? Is the justice system responding to incidents of violence against children in an effective and appropriate manner? Is the justice system dealing with children in contact with the law in a manner which reduces the risk that they may be further victimized or abused? Well, we all know that the justice system is definitely not the only system that has responsibility for protecting children, but its responsibilities are enormous, and the role of the justice system and criminal justice professionals or justice professionals is absolutely critical. So the model strategies were developed to support a comprehensive system-wide and strategic approach in the field of crime prevention and criminal justice. They have been developed to help states to address the need for integrated violence prevention and child protection strategies, and they acknowledge the complementary roles of the justice system on the one hand and of the child protection, social welfare, health, and education sectors on the other hand. Both have a key role to play in creating a protective environment and in preventing and responding to violence against children. So the aims of this new normative instrument is twofold. First of all, is to improve the effectiveness of the criminal justice system. In some cases, it will be the justice system in preventing and responding to violence against children. And also to protect children from violence that may result from their contact with the justice system. So the model strategies provide for a practical framework to identify gaps in existing laws, policies, and practices, to review and design national laws and policies, to set up institutions and mechanisms aimed to prevent and respond to violence against children, and also very important, to guide professionals in their day-to-day practice to effectively prevent and respond to violence against children who are in contact with the justice system. So how this instrument is organized, there are 3 main parts. The first part contains general prevention strategies to address violence against children as part of a broader child protection and crime prevention initiatives. The second part of the instrument contains strategies and measures to improve the criminal justice system's ability to respond to crimes of violence against children and to effectively protect child victims. And the third part, which I would like to focus on right now, is strategies and measures to prevent and respond to violence against children who are in contact with the law as alleged or accused offenders. So under each strategy, there are a number of practical measures that are named and listed rather than fully described. So some of these measures are formulated in a fairly general terms because it would have been impossible to develop an international normative instrument which contains detailed practical guidance for all the countries in the world on how to prevent and respond to violence against children. They will need, therefore, to be refined and adapted to national or local contexts. I would like the organizers to please distribute to those who are interested the presentation because it contains a more detailed description of what contains in part 1, 2, and 3. I will basically, because of lack of time, go directly to part 3, where you have the strategies, as I mentioned, which focus specifically on measures to prevent and respond to those who are alleged as accused of or recognized as having infringed the penal law. So studies reveal that children within the justice system, and in particular those who are deprived of their liberty, as I mentioned before, are especially vulnerable to violence. The consequences of violence, as you all know, cannot be underestimated, notwithstanding the fact that we are this year celebrating the 25th anniversary of the CRC, it's clear, as Philippe mentioned, that the world has achieved wonderful results, but a lot more needs to be done. So despite of Article 19 of the Convention on the Rights of the Child, that all children must be protected from violence, abuse, and exploitation, what happens is that these are the groups, one of the groups of children more neglected by states. So, and this again cannot be underestimated for the cost it has, first of all, to the individual child and to the lack of ability to be functioning adults into society, but to the cost that this represents to society and to communities. So, going back to the strategies, the first strategy that we have in this instrument relates to reducing the number of children in contact with the justice system. This is one of the key areas of work for UNODC. How to promote diversion measures, alternative measures to judicial proceedings to make sure that children will not be dealt with by the justice system, but will be given the opportunity to be outside the system to promote restorative justice measures and other alternative measures to judicial proceedings. There are a number of ways, and you will see in the model strategies a number of elements contained under this strategy number 11. One of them, just to mention, is to avoiding status offenses, so to avoid the criminalization and penalization of children who commit acts that would not be penalized or criminalized if committed by adults, example, truancy, vagrancy, running away from home, and so on. Another key element under this strategy is to make sure that children with mental health problems and children with substance abuse problems will not be dragged into the criminal justice system or the juvenile justice system, but will receive appropriate care and protection. And as I mentioned, another key element is to make sure that diversion and restorative justice programs will be widely used, so it's widen the scope and application of these measures. The second strategy is preventing violence against children associated with law enforcement and prosecution. And elements under this strategy include ensuring that all arrests, detention are conducted in conformity with the law, and of course to limit the detention of children to situations in which these measures are necessary as a last resort. The third strategy is deprivation of liberty as a measure of last resort, which is contained in Article 37 of the Convention on the Rights of the Child. It is well known that children face a significant high risk of violence when they are deprived of liberty. That's why this strategy was included in there. There are a number of elements or practical measures that were included, and they may involve revising sentencing laws, rules, guidelines, and policies. The next strategy under part 3 is related to the prohibition of torture and other cruel, inhumane, or degrading treatment or punishment. So again, it reflects a provision contained in Article 37A of the Convention on the Rights of the Child. In some justice systems, children who have reached puberty are subject to punishment of extreme violence, including flogging, stoning, and amputation. So it was very important, and it was a recognition by the international community of the need to prevent and respond to this phenomenon. Another strategy relates to prevention and responses to violence against children in places of detention. And this includes measures aimed to improve conditions of detention and the treatment of children who are deprived of their liberty. It also includes the need to adopt clear and transparent disciplinary policies and procedures. And the key element under this strategy is to ensure that all alleged incidents of violence against children, including sexual abuse of children in a place of detention, are immediately reported and independently, promptly, and effectively investigated and prosecuted. Another strategy is the protection and assistance to child victims of violence who are in the justice system, and one of the key elements under this strategy is the establishment of complaints mechanisms. And finally, the last strategy that you see on this slide is to strengthen accountability and oversight mechanisms. So numerous studies have shown that violence against children in the justice system remains frequently unpunished. That kind of violence will not be effectively prevented unless strict measures are taken to put an end to this kind of impunity. So any tolerance of violence against children within the juvenile justice system must be challenged, including through awareness-raising programs, education, and effective prosecution of violent offenses committed against children who are in the justice system. Certainly, this is not something, the implementation and the dissemination of this new normative instrument is not something that will be done in the short term. We need to join hands on this, and the United Nations entities have certainly a key role to play, but the role of civil society organizations and governments and members of the academia, media is also key. I would like to give you very important news. On 21st November, 2 weeks ago in New York, a resolution was approved by the General Assembly, a resolution on the rights of the child. And here it's important to acknowledge the key role played by an organization, by Defense for Children International, who played a key role in lobbying and promoting this operative paragraph contained in the resolution. So the Secretary General of the UN was invited by the international community to commission a global study on children deprived of liberty. Congratulations, Defense for Children International, for the great work and for this achievement. I think this is a great achievement for the international community. We keep on repeating that 1.1 million children are deprived of liberty. This is certainly outdated. This is certainly underestimated. Nobody has any clue of the number of children deprived of liberty. And the fact that the international community has commissioned this study to the Secretary General is an achievement, and it means the international community recognizes the importance of the topic and the need to take action. In the same resolution, they linked the need to conduct the global study to the implementation of the violence against children model strategies, and we hope that this will be an opportunity to advance this agenda at international, regional, and national levels. So thank you so much for your attention, and I look forward to continue working with all of you in promoting this new instrument.
Thank you so much, Alexandra, for this clear, concrete, and rich presentation, and also for the presentation about the model. We are running out of time, but I don't want to lose the opportunity to give the floor to all the participants in case that any of you want to raise questions, comments, or thoughts to all the participants. Il y a un microphone, s'il vous plaît? C'est ici.
Thank you for your presentations, all of you. Just have a question for Alexandra. In your presentation, you stated about law enforcement prosecution and to be according to the standards and reflect the children's rights. Do you know any study where it has been done on law enforcement agencies where all of them are on the same board? Because on what I was working at, I saw the discrepancy between the states. Let's say Germany was very violent against the kids. Hypothetically, Greece was mild. Has any been study conducted where all law enforcement are aware of children's rights and how to respond to this situation?
I'm not sure I understood your question, but
in your presentation, you said that law enforcement prosecution should reflect and be mild or reflect and represent children's rights. So, do you know any study that has been done on law enforcement on all member states that have signed the CRC, where law enforcement are aware of children's rights and how to reflect, to treat them when children are in conflict with law?
Okay. No, I'm not aware of a study on this, but what I'm aware is that in the concluding observations of the Committee on the Rights of the Child that Philippe mentioned is a body composed of independent experts with the mandate to monitor the implementation of the CRC. If you go and take a look at all the concluding observations, most of them have recommendations on strengthening the capacity of law enforcement and prosecution officers in dealing with children who are in contact with the justice system. Because this is one of the key challenges faced, well, in the technical assistance work done by UNODC, what we have realized that one of the key challenges faced by, I wouldn't like to say most, but many states, many countries all over the world, is the fact that law enforcement officers are not well equipped to deal with children who are in contact with the justice system, and they are the first point of contact. So it is essential to strengthen the capacity of law enforcement to make sure that, because they are the first point of contact, child rights will be fulfilled by them, and to make sure that children will not suffer from further trauma when in contact with law enforcement. It's one of the key challenges. We are trying hard, jointly with UNICEF and other partners, to make sure that they will be equipped, that their capacity building will be done for law enforcement officers. There is an interest from many states to strengthen the capacity of law enforcement officers. I'm not aware, but I'm sure that Professor Dunkel or other people who are much more knowledgeable than I am, perhaps we refer to studies that were conducted in this area. Thank you.
Thank you.
Hola, buenos días, Marcela
Good
Labraña.
morning, Marcela Labraña from Chile. Question for Alexandra. You asked about how we could have more juvenile justice by not bringing the situation into the judicial system, which is quite encouraging, but it is also quite a challenge, particularly for us Spanish speakers. We are used to always having a judge in their definitions. Having said that, we'd like to know what specific experiences we could apply that are not solved before a court of law and could also bring justice to a child. Thank you.
I will answer in English. Thank you for your question. I think that you touched upon one of the key challenges of juvenile justice systems all over the world, which is, although in many countries and in many Latin American countries, you do find in the legislation diversionary measures or the need to apply alternative measures to judicial proceedings, but in practice, the response will be given by a judge who receives a lot of pressure from the community and from the society to apply, to basically deal with the child within a judicial proceeding, within the formal justice system. There are very good examples, also in Latin America, of restorative justice processes for children. So in a way that whenever, before the beginning del proceso penal, the proceso socioeducativo, before it happens, the child will be referred to social protection institutions, and mediation, family mediation skills, or mediation will happen. A variety of restorative justice process could take place. But what is key here, and I think this is the challenge to be overcome by member states, is to make sure that the cooperation between the child protection system and the justice system will happen. And this is something that does not happen in most of the countries where at least I have been working. This is the key challenge because they don't talk to each other in many of the states. The justice is responsibility of the justice system, de los jueces, de los fiscales, and not of the child protection entities. So above the minimum age of criminal responsibility is the justice system that needs to deal with the child, where we are talking about an interdisciplinary area. So juvenile justice is an area where, yes, there are social workers in the justice system, but they will assist the judge when the child is within the judicial proceeding. And actually, the good practice examples that I'm sure we will talk about in the next 2 days is how do you promote restorative justice programs? How do you promote alternative measures before the judicial proceeding starts? And I think that in countries, I come from Brazil, in Latin American countries, this is a key challenge because different from countries of common law tradition, the police does not, in most of Latin American countries, the police does not have the discretion to divert a child. So it will be the prosecutor and the judge that needs to deal with the child. So we sometimes, I think that some professors do not even consider that it's a diversionary measure, but it's a suspensión condicional del proceso, that not all people consider as being a diversionary measure. In my opinion, it is. And I think that there are creative ways to suspender el proceso, algo así, to divert the child from the system. But the key is how to promote the cooperations between different systems. I think this is what we need to work, and this is what we've worked a lot. This is the strongest focus of the model strategies, is exactly this, how to promote the coordination between different systems. Not sure if I answered your question, but maybe we can continue this discussion later.
Thank you, Alexandra. Mathijs, also wish to raise a question. Just let me introduce you properly. Mathijs Euwema is International Child Development Initiatives Director in the Netherlands.
Yes, and I want to apologize beforehand because I'm going to ask stupid questions to both of you. There's two reasons why I'm going to ask stupid questions. First of all, I don't have a judicial background. I'm a child psychologist. Psychologists tend to ask stupid questions. That's first. The second one, I'm from the Netherlands. We're here in Belgium, so I think I don't have to explain anymore. So my first question is to you. I've read this UNICEF report, and you also mentioned it here during your speech. Somewhere it reads, accessible justice systems attribute directly to inclusive and sustainable development. And my question to you is, where do you base that on? Because there are a lot of countries where the justice system is quite flawed and they develop just fine. Just a few examples: USA, UK, the Netherlands, basically every country in the Western world. So where is the proof that accessible justice systems lead to sustainable development? This is a very difficult question. Stupid, but difficult.
No, it's not that stupid. No, it's indeed, 25 years after the convention. The world has changed. The fact that we have placed, recognized, I would say, the centrality of children in everything we do is really leading to sustainable development. You see the SDGs, now we're almost ending the conversation of the post-2015 agenda, and for those who are engaged, and I'm sure a lot of you are engaged, the centrality of children is in there. And this is very, very new to continue with this agenda for the international community. So they understood, finally, that realizing the rights of children, of youth, is the best way to have sustainable societies. How can you have sustainable development when you have your youth demonstrating, fighting, being harassed, being violated, being married early? For instance, girl, you don't go to secondary education, forced to marry. This is certainly not the best way to develop a country, to use all the potential you have in the country. So I think, proofs, more and more studies are there, and I think there is strong political will here and there as well. We are not yet there. This is certainly a long journey again. You were talking about 25 next year, certainly something. But more and more, you find, in Europe, you are from the Netherlands. Look at the situation for youth in terms of employment, in terms of their rights. There are quite, people with disability, children with disability, even in Europe, with a rising poverty affecting children. Not to blame anybody, but the Committee on the Rights of the Child recently scorned the government of Portugal, saying that they were not doing enough on that. And it's the same for Germany, same for France, my country, for all of them. So at the end of the day, there is, and we count on on us, because the fact that we are together as a network of activists having different outreach, whether it's EU institutions, government, NGOs, community-based activities, local authorities, also very important, Committee of the Regions, also the private sector. I mean, we had Monsieur Malos from the Conseil économique et social. Those are extremely important forces. Before, you would never have seen trade agreement being negotiated with conditionalities on children, particularly with regard to child labor. It's coming up. That's the way. So this is perhaps my stupid response to your stupid question, which is not that stupid, but this is really moving in that direction. And thank you for that question.
Okay. Now, Alexandra, she's already looking. It's going to happen. Now, first of all, you said somewhere during your speech that it's you cannot develop a normative instrumental network that works worldwide. So, first question would be, why would you want to develop one in the first place? But okay, I will not go into that. But actually, this morning in the train, I tried to read the whole thing, which, as you said, is not so easy. As psychologists, we know beyond 7 points, people tend to forget the first point. So that's one thing. But there were a few things in there where I have some questions. And one of it is, one of the things that is mentioned is the importance of parental capacity building. As a psychologist, I know that making bad parents better parents is virtually impossible, or at least very seldomly effective. So why is it in there if you talk about evidence-based? A similar one, maybe a bit more controversial, also is mentioned we need more public awareness campaigns. Public awareness campaigns are notoriously ineffective in changing mindsets and attitudes. So there's a lot of stuff in there. I'm just I'm saying it from a child psychologist perspective, where first of all, I feel they are so broad, as you said. So what can people do with it in the end anyway? And secondly, some of them are at least, let's say, doubtful if they're going to really contribute. So.
Thank you. With your permission, I would like to respond to the question, merging actually the two questions, the one raised to Philippe and the two raised to me, because I think they are interconnected. You asked Philippe about accessible justice systems, and I think here it's key to talk about what is the meaning of accessible justice systems. So access to justice has been defined in different ways by different organizations. I personally like the definition of the World Bank that basically looks at access to justice from two different perspectives. Access to justice from the supply side, it is what is the capacity, from the supply and from the demand sides. So what is the capacity of justice institutions to deliver justice in an effective, fair, and equitable manner? And from the demand side, what are the conditions created for people to claim their rights, and in this case for children to be able to claim and exercise their rights? I think the definition is key because it sets the ground for what exactly we're looking for. And your first question was actually very interesting, so I'm very tempted to just add something to what Philippe said. Evidence-based, yes, the world is lacking evidence on everything, especially on justice. The UN has recently developed indicators on justice system. We are at this stage within the UN Secretariat trying to apply the indicators in some of post-conflict countries. But I think just one sentence could actually link what is so obvious to most of us, the linkages between justice and development. Now we are in the process of finalizing the post-2015 agenda, and we really hope that goals will be included in terms of violence prevention and the key role of the justice system in promoting development. So ineffective, unfair justice systems will necessarily lead to lack of trust by the population, by the public at large, in the institutions. It will lead to the decrease, just to mention examples, of foreign direct investment. So it will certainly lead to conditions that will prevent countries from developing. And development here, I would like to mention, Amartya said, we're not talking about only economic development, but we are talking about development, human development and development as a whole. So it will have an impact on the functions and capabilities of human being to be functioning adults and kids to be functioning adults in the society and to promote at large sustainable development. Linking to that, to parental capacity building, parents, because of the vulnerable conditions of children, especially when they are young and they are within the within the juvenile justice system, some of them are 6, 7 years old, and they are in the system. So the parents or responsible adults, in the absence of parents, have a key role to play. Parental capacity building, because especially, as I mentioned before, in diversionary measures and restorative justice programs, it is important to involve the household, it is important to involve the parents, it is important to involve the community, because social reintegration or rehabilitation of the child who is alleged as accused of or recognized as having infringed the penal law is not a child as an individual, but we need to mobilize a number of stakeholders who surrounds this child, so parents have a key role to play. And this is a very obvious statement what I'm saying here, so I apologize for that, but that is why it is included in the model strategies with a strong focus. It has always been included in a number of other normative instruments. Either I did not express myself clear or I could have been misunderstood. I didn't say that it's not possible to develop an international normative instruments to all countries. What I said is that this normative instrument contains strategies and practical measures. And on purpose, we did not go into details on the practical measures because they will necessarily need to be adapted to the local context. And that is what I mentioned. There are different legal systems. You have common law, you have civil law, you have Sharia law. And of course, you cannot go into details on how the prosecution service of Chile need to implement and which measures to prevent and respond to violence against children. And finally, and I apologize for talking too much, public awareness campaign, you mentioned that they are ineffective. I think they can be extremely effective. I think it depends on how they are developed. I think it's important to join hands when any public awareness campaign is being developed. You need to have the buy-in of stakeholders. You need to have the buy-in of the media. Sometimes you need to have the buy-in of schools. I think that the challenge that we face when conducting or implementing awareness-raising campaigns is that they tend to be isolated. And I think it's difficult to be successful when they are isolated. But at the same time, they are key to promote the engagement of the public, because without, for example, the role of the media nowadays is so key in promoting, even in Europe, if you read the news even this week, in Germany, for example, there is a tendency to be tougher and tougher on crime committed by Latin America is another, I think worldwide there is a tendency to be tougher on crime committed by children and young people. The media has a key role to play. This is not evidence-based, fortunately, so we have the possibility to work against this trend, and I think that without awareness-raising campaign, we may be unlikely to be successful. Thank you.
Thank you, Alexandra, for your responses. Thank you, Mathijs, for your critical thoughts and the questions that you raised. I think that these questions help us to conclude the session and to raise the main guidelines. I just want to thank all of you for being here. I'll invite you to get to the other room. We will be having our tea and coffee, and I will ask you to be brief because next plenary session will be of extreme interest for all of you. Thank you.